Hello everyone and welcome to today's Mondac webinar in association with Hoffer Adler LLP, who will be discussing recent topics in franchise, trademark and intellectual property protection. My name is Dan Sampaio and I'm joined by a brilliant panel to take us through today's discussion. Stephanie Chong is a partner at Hoffer Adler. She practices intellectual property law with an emphasis on the strategic acquisition, management and enforcement of trademark and other IP rights. Stephanie advises entities ranging from small and medium-sized enterprises to large multinationals. She represents clients in proceedings before the Trademarks Opposition Board, as well as the Ontario and federal courts. Stephanie is also a registered trademark agent, and Stephanie was also the past president of the IP Institute of Canada. Idan Erez is a litigation partner at Hoffer Adler. He is a member of the bar in the province of Ontario and in the state of Georgia. Idan's practice focuses on a variety of subject matter, including franchising and other commercial disputes, professional liability, personal injury defense, and other types of civil litigation. Idan has been recognized by his colleagues as a Franchise Times legal eagle. Before I hand over to the panel to begin today's webinar, a housekeeping item. You can submit questions to our panel by typing them into the questions pane of the toolbar on the right-hand side of your page. The panel will endeavour to answer as many questions as possible during our Q&A session, but please do reach out afterwards for any additional information that you may require. It's now my pleasure to hand you over to Stephanie and Idan to begin. Thank you.
Thank you, Dan, for that warm introduction. Hello, everyone. My name is Idan. I'm a litigation partner at Hoffer Adler. If you're in Canada or the States and do franchise or IP work, then chances are that you've heard of our firm. And for those of you joining us from outside of North America, welcome. We're a business law firm based out of Toronto. We're mostly known for our franchise and trademark work, although we practice in lots of other business and IP areas. In a moment, I'm going to hand it over to my partner, Stephanie, who is going to be doing most of the talking today. Stephanie is going to discuss key changes to the trademarks regime and recent cases in Canada that are either specific to franchises or would have applicability to franchises. Stephanie?
Thanks very much, Idan, and good morning, good afternoon, good evening, depending on where you are in the world. It's lovely to have a chance to speak in front of a global audience. So if I could have the next slide, please. I thought I would just throw this quote up because I think it's very apropos of today's topic. The most precious possessions of the franchisor are its trademarks and its system. And this was a quote from a case of the Ontario court many years ago, but it still remains relevant today. Next slide. So just to go through a quick roadmap of what we're going to be talking about. I don't think that I could have done this presentation justice without starting with an overview of the key developments in Canada's trademark regime. We have had some significant changes over the past number of years, so I'm going to start with that. And the next 5 bullet points really deal with case law. I may not get through all of it, but it will be in the slides. So the first 3 bullets there, the franchise that is not yet launched, franchise that has been stalled, and debranding, those are cases that specifically deal with trademark issues in the context of franchises. The next 2, licensing and bad faith, are kind of franchise adjacent, if you will. And then the last one is a specific legislative provision for the province of Quebec, which I probably will not have time to address, but I will do my best. Next slide. So in terms of the changes to the Canadian trademark landscape, many of you who work in the area of trademarks may be aware that major amendments came into force on June 17th of 2019. And I've listed some of these amendments. These are not all of them, but they are some of the major ones that I just wanted to quickly touch on today. So the first one has to do with the statement of use in the application. The next one has to do with the implementation of the NIS classification, the implementation of the Madrid Protocol, and then the ability of examiners to object to applications on the basis of something called lack of inherent distinctiveness. So if you're joining us today and are not a trademark lawyer, no worries, I will go into some of the background of this so that hopefully it's not all mumbo jumbo. Next slide, please. So with respect to the use requirement, use is the underpinning of any trademark in terms of maintaining its validity. So it really is a rule of use it or lose it. And under our prior Trademarks Act, we had two requirements in terms of the applications. You had to either put that the trademark had been used in Canada since a specific date, or since at least as early as a specific date. And if it hadn't yet been used in Canada, you would need to file it on the basis of proposed use or future use. And for those applications based on proposed use in Canada, the registration would not issue until you filed a declaration of use. So our system was very similar to what is in the US and what continues to exist in the US. So you needed to have use before you could even get a registration, with some small exceptions that are not really relevant here. But under the current act, the government did away with these requirements. So you can simply just file a trademark application. You don't have to say whether you've used it, and you don't have to file a declaration of use. So what happened with this is that there was a spike in applications because you didn't have to say whether or not you had used it. And so that really encouraged an increase in the number of applications. And you may be wondering that whether the lack of requirement to specify use would allow people to squat on trademarks. And the answer is really no. I mean, there was some of that, but as we will see later, there is now a prohibition, an express prohibition against trying to register a mark that was filed in bad faith. Next slide. Canada also aligned itself with most industrialized countries in the trademarks world by formally adhering to the NICE classification system. So these are NICE classes, they're not nice classes. Sometimes they're nice, sometimes they're not so nice. And this is by way of treaty. There are 45 classes in total, because of course trademarks have to be filed in association with specific products or goods and specific services. So those are divided into 45 classes. I've put the government fees there just for your reference. These are in Canadian dollars. And again, before June 17th of 2019, it was nice and easy. So that was nice, a $250 flat fee, regardless of the number of classes. So that again led to a spike in applications just before that June 17th, 2019 date, because people could put in all kinds of goods and services for one nice low flat fee of $250. So next slide. Quite significant is the implementation of the Madrid Protocol. And the way that this works, for those who may not be familiar with it, is that you file a trademark application in your home country. And then based on that, you can file an application for a so-called international registration through the World IP Office. And in that application for an international registration, you simply tick the box with the other countries that are of interest to you. So you are trying to use that application for the international registration to go outside of your home country into other countries of interest. WIPO basically just gives it a rubber stamp. They check for very basic formal requirements, and then presto, you have your international registration. However, that international registration does not become effective in the designated parties until each country has had a chance to examine that application in accordance with its own requirements. So this was a real game changer for Canada to be able to adhere to this treaty, because no longer is it necessary for Canadian applicants to file in individual countries outside Canada, and conversely, foreign entities can now designate Canada as a party for the international registration. And there are several strategic considerations, but the impact of Canada's adherence to the Madrid Protocol was, again, a significant increase in workload for the Canadian IP office. I just returned from an international trademark conference in Singapore, and I attended the working group meeting hosted by WIPO, and they gave some statistics. So Canada is the 4th most designated party under the Madrid Protocol in terms of incoming applications to Canada, 4th most globally. And in 2022, there were over 22,000 designations under Madrid, which is very significant. So it's led to an increase. Okay, next slide. And the last development I wanted to mention is that examiners in Canada can now object to a trademark application on the basis that it is not inherently distinctive. So what that means, this is definitely trademark speak, but there is a sliding scale in terms of registrability. So we have marks on one end of the scale that are purely descriptive or generic, like cold ice cream or frozen ice cream or something like that, versus distinctive. Which may be, I mean, in our market, you know, Baskin Robbins or Haagen-Dazs. These are distinctive brands for ice cream. But then somewhere in the mushy middle, you have things that are maybe suggestive. And so clearly descriptive marks like frozen ice cream are definitely not registrable, but suggestive marks should be registrable. And I'm thinking of a restaurant brand here called Freshie, for example, which is the word fresh with 2 I's on the end of it. That is a suggestive mark. It suggests freshness in the food, and that should be registrable. What's happening now is that examiners are sort of picking up on these suggestive marks and objecting to them on the basis that they are not distinctive, that they're not inherently distinctive. In that they believe the mark to be descriptive or perhaps commonly used by others in the same area. So this has led to a slowing down of the processing of some applications. And all of these factors have to be considered in the context of the fact that we've just come out of a global pandemic. So what has been the impact? Next slide. The impact has been that, unfortunately, applications in Canada are being examined somewhat at a snail's pace. I do have some statistics there. These were taken from the Canadian IP Office website a few days ago when I was preparing these slides. You will see that Madrid applications are taking about 16 months to be examined, and that's because if CIPO is going to issue an objection against an incoming Madrid application, they have to do that by the 18-month mark. So 18 months after WIPO has notified the Canadian office of the designation. And then non-Madrid applications are about 19 months to be examined, but that's only if all the goods and services are pre-approved. So what does it mean to have pre-approved goods and services? Well, these are taken from the Canadian IP Office's Goods and Services Manual. And this is a constantly evolving list of goods and services. So Canada actually requires a very high degree of specificity in its description of goods and services. So the first trick is to go to that manual and see if your goods and services can be described that way. If you're not pre-approved, it is taking a really, really, really long time. And there are some applications that date from 2019 that haven't even been examined yet. CIPO is taking steps to clear this backlog, but in the meantime, you can expect a longer than usual wait. So next slide. Okay, so the takeaways from all of this for franchises, especially if you are thinking of entering Canada, obviously consult with Canadian Trademark Council to see if you can use one of these mechanisms. Use the pre-approved terms to the extent that it's suitable, and it's not always going to be suitable. If your term is not in the goods and services manual, there is a way to request that it be placed into the goods and services manual. So that is one trick to keep in mind. Use the Madrid Protocol if it's strategically sound. And again, have a conversation with your local trademark council and your Canadian Trademark Council to see if it makes sense in this particular circumstance. And then there are different ways where you can expedite an application. So specifically, if you're expecting to sue somebody on that trademark, in the case of counterfeits. And then the third one is actually, I think, quite common. If you are finding counterfeits, for example, on Amazon or other online platforms, and you're saying, hey, I need this registration so that I can tell Amazon to stop these counterfeits. There are ways of communicating to CIPO that this is necessary. And then finally, with the non-inherent distinctiveness objections, again, ask Canadian Council. Those of us who work in this area, we're very familiar with what needs to be done to try to overcome these objections, and even front-ending it. Just run it by Canadian Council to see if you might get an objection so that you can be a little bit more proactive in your brand strategy. Okay, next slide. So now we're getting into the case law, and I wanted to start with this case here, which deals with a franchise that had not yet been launched and what it was trying to do to protect its brand. So this is known colloquially here as the Bombay Frankies case. It's a decision at first instance of the Ontario Superior Court. And the dispute was over the trademark Bombay Frankies. One party was using it with an S or wanted to use it with an S. The other one was using it without the S. Now, a Frankie is apparently a common street food in India. And if you just look at the relevant facts, it was at the end of October of 2020 that the plaintiff, which was the numbered company in this case, filed a trademark application to register Bombay Frankies. Okay, but at that time, there were no actual restaurants open. So there was no use. They were just getting off the ground. They did what their trademark lawyer probably recommended to them, which was get that trademark application on file as soon as possible. And the court at first instance said that since they filed the trademark application, they had invested quite a bit of time and energy to try to launch this franchise. And you'll note that there were a number of negotiations currently ongoing, but that to date, as of the date of the hearing, no restaurants had been opened. So there had been no use of the trademark, only a pending application. So next slide. Now, fast forward to the following year, the defendants, Bhagwani and his companies, actually opened a Bombay Frankie restaurant. So they were allegedly the first to use the trademark. Now I have a little question mark there because there is a reference in the appeal decision that there was a strong dispute between the parties as to who was actually first to use. But nonetheless, it does appear that the defendants were first to open a Bombay Frankie restaurant. So in contrast, the plaintiff only had a pending trademark application with no use. Now, what happened? The plaintiff was not happy that Bhagwani had opened up a Bombay Frankie restaurant and was essentially trying to sort of scoop, from the plaintiff's perspective, scoop the concept from the plaintiff. And the plaintiff moved for an interlocutory injunction. Now, those are somewhat difficult to get. There's a three-part test to obtain an interlocutory injunction, and it's usually not that easy. The trial judge made a reference to the fact that the concept of use or prior use is no longer required pursuant to the new Trademarks Act. And this was the very mischief that the Trademarks Bar was afraid of when the use requirements were removed from the legislation. And this trial judge sort of glommed onto that and then referred to the fact that a lot of work had been put into this by the plaintiff. Next slide. So interlocutory injunction was granted to the plaintiff on the basis of a mere pending application and no goodwill developed in the mark. And this was the reaction of the trademarks bar at the time. It was sort of, what? How could this be? So it went to appeal. Next slide. It went to appeal to the divisional court, and thankfully the decision was reversed and all was made right in the trademarks world. The appeal division pointed out that the plaintiff did not yet have a trademark registration, only a pending application, no goodwill, and that with only a pending application, you cannot assume that it's going to be registered, because anything could happen. The examiner could object, a deadline could be missed and the application would become abandoned, or someone could oppose. So I think here it's the principles of trademark law remain as they were and as they have always been in our system, that a pending application does not really provide you with any rights, and certainly not enough upon which to get an interlocutory injunction. So next slide. There were some very interesting comments in Obiter, and I do have a picture of a slightly open door, because I was thinking about this as I was preparing for this, and it seems to me that this may kind of open the door a little bit to maybe being able to do something with this fact scenario. And what the court said here is that goodwill could exist from the potential of prospective franchisees, okay? But there was no evidence on the record to support that. So next slide. One of the takeaways that I think we may be able to gain from this case is that you can actually include franchising services in a trademark application. And perhaps if that had been done, and if there was evidence that there was confusion among prospective franchisees, then perhaps, I'm saying I don't know for a fact, but that would at least been, you know, something that they could have hung their hat on, the entity that had filed the first application. And of course, there is the possibility of using the expedited examination process to get the registration if you find yourself in a situation like this. But it does remain a tricky situation in terms of preventing others from simply launching a brand before you are quite ready to do so. Okay, next slide. So the next case deals with a franchise that was kind of stalled. And this has to do with the right to maintain a registration when there has not been any use of the trademark. So remember I said at the beginning that our trademark system is based on a use it or lose it scenario. And in this case, this dealt with a proceeding pursuant to Section 45 of our Trademarks Act. What that provision allows third parties to do is to go to the trademark registrar and say, hey, there's this registration here, and I want you, please, registrar, to ask the owner of that registration to prove that they have actually used the trademark within the past 3 years. Okay, so this is a mechanism that is very commonly used to get rid of what we call deadwood. So marks that have been on the register that have not been used for a period of time will be struck, and it can clear the way for other similar or identical marks to become registered. So the relevant period is 3 years before the issuance of the Section 45 notice, and I've got the relevant dates here. We can move to the next slide. And just for ease of reference, I've repeated the relevant dates at the top of this slide. And here's what happened in this case. Within that relevant period, the rights had actually been sold including the trademark rights, from the previous owner to the current owner. And then sort of in the middle of the relevant period, they only had one franchisee in Canada. And then that franchisee had left the system. I don't know the date because it's not mentioned in the decision, but presumably at some point in the relevant period, there were no franchisees in Canada, only in the United States. However, just about a month before the end of the relevant period, there was a franchise agreement that was signed by a new Canadian franchisee. So the trademark owner was able to onboard a new Canadian franchisee, but that franchisee was not up and running by the time the end of the relevant period had come around. So next slide. So in the result, there was no evidence that the trademark had been used in Canada during the relevant period. So without use, the trademark will be struck unless there's a saving provision. So the saving provision can come up if there are special circumstances. So next slide. And here I've listed the criteria for what the registrar considers when they're looking at special circumstances excusing non-use. So here there was non-use of the mark for 32 months. And the hearing officer then had to ask whether the reasons for non-use were beyond the control of the trademark owner and whether there was a serious intention to shortly resume the use. Next slide. So there were special circumstances excusing non-use, and I've taken a quote from paragraph 28, and it really just refers to the fact that the trademark owner had gone through a significant effort to get this Canadian franchisee on board and was trying to recruit other franchisees. They had produced a disclosure document, and they had complied with the Ontario legislation for franchises, which is called the Arthur Wishart Act, as well as the corresponding legislation in Alberta. And so they had gone to quite some effort here. And that resulted in a new Canadian franchisee signing an agreement on November 9th of 2020. So here, there was no use of the trademark, but there were special circumstances to excuse the non-use. And those special circumstances consisted of these efforts to get Canadian franchisees up and running. Next slide. So here, the serious efforts to franchise in Canada can constitute a special circumstance. Now, I kind of wonder whether the result would have been the same if they had not been able to sign up a Canadian franchisee within the relevant period. So to me, that's a little bit of an open question. And another notable takeaway from this case is that even though COVID was referenced, the hearing officer did not hang his hat on COVID as a valid reason to excuse non-use. I personally think that we're beyond the point in time where we can just put our hands up and say, COVID is why I haven't been able to use my trademark. I don't think that that's going to fly anymore unless you can combine that with other circumstances such as this.
Stephanie, to me, it sounds like this case is similar to Bombay Frankie's in that it raises the question of how a franchisor can support a franchise registration when there's no prior use. And it sounds like the court is saying, here at least in the Section 45 context, that it's the thought that counts, provided the thought is backed up by significant investment. Is that your take on it too?
Yeah, I think that's right, Dan, and that's a really good comment. You know, another thing to keep in mind is that the two proceedings, even though the facts are somewhat similar in the sense of franchises trying to get launched, they're very different contexts. So this one here in the made right decision was a Section 45. The bar is actually very low, and you know, the registrar will typically try to find use if they can, if it's reasonable to do so. So it's a very low bar to maintain an existing registration. But contrast that with Bombay Frankie's, where there was just a pending application and they were trying to get an interlocutory injunction. I mean, so it's a totally different framework. And that's why I think similar facts went in favor of the franchisor in the Section 45 case, but against the franchisor in the interlocutory injunction case. So,
makes sense. Thanks.
okay, so next slide is a new case, and this is the last case that I'm going to discuss that is franchise specific, and this deals with debranding. Okay, so the franchise brand, the trademark, was Signature Vape. Unicity was a former franchisee, and British Vape was the former franchisor. So there was a termination of the franchise agreement. They did that through mediation, and minutes of settlement were signed. And under the minutes of settlement, the former franchisee, which was Unicity, agreed that it would essentially debrand. So they said, we're going to paint the store in a different color. We're going to remove this chandelier, and then immediately cease using any and all designs, branding, or marks used by Signature Vape. So very broad language, and this is taken from the wording of the minutes of settlement. So they repainted, they got rid of the chandelier, but they kept certain elements of the look and feel of their bricks and mortar store. So the settlement terms ended up being disputed. Next slide. And in particular, Unicity continued to use gray tiles and glossy black cabinets. And British Vape said, hang on, you can't do that because this is part of our unique design. It is part of our unique look and feel. The problem was these specific features, the gray tiles and the glossy black cabinets, were not actually listed in the franchise agreement as part of the IP belonging to the franchisor. They were also not mentioned in the minutes of settlement. Next slide. So the result is that the court found that the debranding had been sufficiently complied with. And they sort of drew an analogy saying that as a result of the rebranding of Unicity store, that they did resemble each other, but only in a way that a Rexall resembles that of a Shoppers Drug Mart. Those are the two major drugstore chains in Canada, or a Burger King resembles a McDonald's. The overall impression is similar as the products and businesses are similar, but the branding details are different. And here's the crux of it. And consumers are certainly able to distinguish the brands. So next slide. So this was confirmed on appeal. It did go up to the Ontario Court of Appeal, and the appellate court basically repeated that the franchise agreement and the minutes of settlement did not actually include the gray tiles and the glossy black cabinets. So takeaways, next slide. If you're a franchisor, you should be very specific about what you consider to be your IP. So if these gray tiles and glossy black cabinets were so key to the look and feel of Signature Vape, then they should have been listed in the franchise agreement. And you know, I do have a bit. Sorry.
Go ahead. When you're done with the slide, let me jump in with a comment.
Okay, just a quick ancillary point here is that there was another provision in the minutes of settlement where the franchisor had agreed to pay the franchisee $100,000 upon the discharge of certain liens. The liens were discharged, and then lo and behold, the franchisor withheld the payment of the $100,000 on the basis that they felt the debranding had not been sufficiently complied with. So the court said, bad franchisor, you should not do that because you can't withhold payment for a corollary purpose. So they should have paid that. This was found to violate the duty of fair dealing owed by a franchisor to a franchisee. So, Edan.
Sure. I just want to add that as a litigator, I quite like the idea of particularizing the distinctive elements of your brand if you're a franchisor, because it's going to help not only with IP issues like those that were an issue in this Great British Vape decision that we're looking at, but also in enforcing your restrictive covenants, things like your non-competes. So I think the more clearly you define what's distinctive about your brand right in the franchise agreement, the less opportunity you leave for your franchisees to benefit from your brand when the relationship ends.
Yeah, I think that's a great comment and a good practical takeaway as well. Okay, so we'll move on to the next slide. So the next couple of cases are not specific to franchises, but they are very relevant, I think, in the broader landscape of franchises and trademarks. So this is the Milano Pizza case. And just by way of background, going back again to the concept of use has to be in evidence in order to maintain the validity of a trademark. And of course, a franchise agreement will include a trademark license, and trademark licenses also exist outside the confines of franchise agreements. They are very often just standalone agreements. So if you have entity A and they want entity B to use the trademark and those two entities are different, then you would typically have a license agreement in which the owner licenses the user to use the mark. And if the license is properly structured, then any use by the user is deemed to be for the benefit of the owner, okay? So this is dealt with in Section 50 of our Trademarks Act. And the key words here are highlighted, that the owner has to have direct or indirect control of the character or quality of the goods or services. So they can't just simply say, okay, licensee, go ahead and use this trademark, and not actually control. So the license agreement has to have control provisions in it. And not only that, those control provisions actually have to be exercised. So it's not enough to just have a paper agreement where you're going to say that you control the mark. You actually have to demonstrate that you have controlled them. So next slide. So what happened in this case is that Milano Pizza Limited claimed against a series of entities. This was a very messy family dispute, by the way. All the parties seemed to be directly or related to each other or related through marriage. So it was a case of the Milano Pizza owner of the trademarks having entered into business deals with family members who were alleged to be former licensees. And then there was a breakdown in the relationship. So the plaintiff sued for infringement and other causes of action. So as is commonly the case, when a defendant gets sued for trademark infringement, they will counterclaim to say that, well, we're not liable because guess what? Your trademark registration is invalid. So they counterclaimed for expungement of the Milano Pizzeria mark, which is shown here. And they were successful. They got the registration knocked out. And this case was a closely watched case because it does go into quite a bit of detail as to what was going on with respect to the use of the mark and whether or not the trademark owner was actually controlling the use or not. It did go up to appeal, and the appeal decision was only just rendered on April 27th, so it's really hot off the presses, and the appellate court affirmed the decision of the trial judge. The trial judge, by the way, is a former trademarks lawyer, and so this decision stands. So next slide. And really here, this is just the key issue, is whether the plaintiff had demonstrated sufficient controlled licensing within the meaning of that provision of the Trademarks Act. Next slide. So here what I've done is kind of set up a bit of a chart that summarizes the evidence from the case, or what I thought was the key evidence from the case. And on the left side, I've listed the factors that would tend to support the existence of a valid license. And on the right side, I've listed the evidence that tends to negate the existence of a valid license. So on the left side, you'll see that there were some requirements to purchase products from certain suppliers, menu approval, some references to the need to consistently use the trademarks in signage. So, you know, things that would typically be found in a license agreement. But what really went against the plaintiff were the factors on the right, that there was no right of inspection. And this is usually pretty key in a trademark license, that there usually is a right to inspect the products or the services. So that was not present. And, you know, there were others, but I really think the key is the second point on the right-hand side, that the licensees were largely free to operate their businesses as they saw fit. So they were given free rein to do anything, decor, advertising, staffing, uniforms, and even down to the pricing. So there was no uniformity in this at all. Next slide. And what the court said, that the trial court said, that the plaintiff had not satisfied the court that it had exercised sufficient control. And then the other point, which is of interest to a franchise audience, is that some of these written agreements, so the written agreements were not consistent, and there were no written agreements in evidence for all of the different licensed locations. So they were a little bit selective, but the ones that were in evidence, some of them referred to license/franchise fees and royalties. But the court was quite firm in finding that the plaintiff was not a franchise, as defined in the Ontario legislation. And the plaintiff did not show that it had exercised significant control or provided significant assistance to the licensees. And those last two factors are essential to the finding of a franchise. So no franchise in this case, in spite of the fact that the agreement said, oh, these are franchise fees. So next slide. So just a couple of takeaways from this. Of course, if you do want to be considered a proper franchise, you have to comply with the applicable legislation. And then if you are, on the other hand, just wanting to be a license, a trademark license, and not a franchise, you have to have actual control, and it has to be exercised. And it's really just a question of degree as to how much control you should ultimately have in that trademark license agreement.
Stephanie, is there some kind of bright line if you were a trademark owner and you just want to license the use of your trademark, but you don't want to find yourself in a position where you're a franchisor and you've got all kinds of franchise obligations to the people that you're licensing your trademark to?
Yeah, I don't. It's a great question. It's something that we talk about internally in this office, and the answer is no. There really is no bright line. I mean, the trademark license agreements will tend to be a little bit more robust when the entities are not related to each other. If it's just an intercompany trademark license, then it tends to be a bit looser. But the degree of control, I mean, I would just say you probably don't want to have control over every aspect of every day-to-day decision that the licensee is making, because then it starts to look a lot more like a franchise. But no, there's no bright line.
Okay, thanks.
Okay, so the last case that I'm going to discuss, just make sure it is the last case. Yes, it is. So this case is notable, again, not directly having to do with franchising, but very relevant in the franchising space. This had to do with a restaurant called Beijing Judian, and they sued an individual named Wei Meng. And what happened here is that Beijing Judian was the Canadian arm of a restaurateur in mainland China. And Beijing Judian had owned a number of locations in China, quite well known in the Chinese community, both in mainland China and abroad. And then they expanded into Canada, into British Columbia. Lo and behold, Mr. Meng got a trademark registration for one of the Judian trademarks, and it's shown below. It is quite complex. It's not just something that you would come up with, overnight. It has very stylized Chinese characters in it, and then a little design on the right. And so Beijing Judian did manage to get this ultimately fraudulent registration expunged. And this was done on the basis of bad faith. So the reason that this decision is notable is it's the first decision in which our provisions relating to bad faith registration were successfully tested. So next slide. So as I alluded to at the beginning of this presentation, one of the other amendments to the Trademarks Act was to introduce expressly the concept of bad faith. And this can be applicable in the context of both the validity of an existing registration. So a registration of a trademark is invalid if the application for registration was filed in bad faith. So note the relevant date there. It's the filing date, and you have to prove that it was filed in bad faith. And similarly, when a trademark is opposed, so again, for the non-trademark people on this call, an opposition proceeding takes place after an application has been internally approved by the Trademarks Office, but before it's registered. So there is a window of opportunity prior to registration in which a third party can try to oppose an application because they think that the applicant should not get a registration. So again, this bad faith provision is mirrored in the grounds of opposition, that the application was filed in bad faith. So next slide. So as I mentioned, the applicant owned a number of well-known restaurants in China. So when I say the applicant here, I mean that the legitimate trademark owner here, Beijing Judian. Now, they were the only ones who filed evidence, and they were not cross-examined on that. I don't recall whether Mr. Meng was unrepresented in these proceedings, but he did not file evidence. Another note here is that the applicant, Beijing Judian, it sounds like they only became aware of Mr. Meng's registration when they themselves tried to register their legitimate trademark. And lo and behold, they were blocked by Mr. Meng's application, which eventually matured to registration. So next slide. So what's notable about this case, as I mentioned, is that it's the first time that bad faith was found in the context of an invalidity proceeding. And the court went through quite a detailed review of what that could potentially mean. And they relied on legislative history. They also looked to some case law that has been decided in both the UK and in Europe. Both of those jurisdictions have had bad faith provisions in their statutes for a number of years. And ultimately, the court found that bad faith could be found if there is a breach of a legal or moral obligation. Next slide. And here there was quite a bit of evidence in which demonstrated Mr. Meng's bad faith. He had a pattern of applying to register marks of other restaurant chains. He threatened Beijing Judian. He ended up advertising the trademark for sale online. A private investigator on behalf of the plaintiff made an inquiry, and his response is there, well, just pay me $100,000. And, you know, so kind of very good evidence, I think, to support bad faith. So next slide. Now, Mr. Meng did not participate in these proceedings, as I mentioned, but another factor is that the trademark in issue was quite intricate, as I pointed out. And the court did find it implausible that Mr. Meng would be able to come up with a trademark on his own. So they found that the intentional filing of a well-known trademark coupled with Beijing Judian's reputation among the Chinese Canadian population showed bad faith. So it is still somewhat a high bar, and you can see that there was quite a bit of evidence here that Beijing Judian had to put on the record, including its reputation among the relevant population in Canada. So I'll just go to the next slide actually, but one thing I wanted to mention here is that it's really important, I think, to be proactive in your trademark strategy, particularly if you are a foreign brand coming into Canada. We have an extremely diverse population in this country, and our diaspora is very diverse. And, you know, I'm constantly hearing statistics that our population from X country is, you know, the second largest outside of whatever that country is, you know. So we have a lot of room in our local market to absorb foreign brands or brands that are well known outside of Canada. So with that in mind, I think it's really important to be very proactive in your trademark strategy. And even if Canada is just a glimmer in your eye, just get that application on file, and then be proactive, because, you know, one of the oversights it appears that Beijing Judian made in this case was that they were not monitoring third-party filing. So Mr. Meng was able to get a registration, whereas if they had stepped in earlier in the process, they probably would have been able to stop it from becoming registered to begin with. And opposition proceedings are, generally speaking, much more streamlined and much more cost-effective than litigation.
On the proactive point that you just made, I think that's good advice, and I just wonder what you do if you're in a Bombay Frankie's position where you want to be proactive, but you're having a hard time demonstrating prior use.
Yeah, so, you know, there is no easy answer for the Bombay Frankie's situation. And, you know, I think to some degree, that's why they managed to be successful at trial, because it just seemed as though the equities would weigh in their favor. But there really is no easy answer to that. I mean, I think I've mentioned some potential practical strategies, maybe including franchising services within your application, trying to launch, you know, making bona fide efforts to launch, and again, just monitoring for other filings and monitoring the marketplace. And, you know, there's always a lot of things can be resolved outside. You know, sometimes they say get the lawyers out of the room and it'll work out better for the parties. But just keeping in mind some of those business, like non-legal business strategies as well, right? So it really is a mixed bag. There's no easy answer.
Okay.
I know that we're getting towards the end, and I only had one last slide on Bill 96, which, you know, everyone is welcome to read, but it is a hot topic right now. Just make sure you comply with French language laws if you are planning to do business in the province of Quebec, and that's all I'm going to say about that. So 5 minutes left. I don't know if there are questions to address at this point.
I don't see any questions so far, but I'm still thinking about the last case that you talked about and this notion of bad faith in trademark law. It seems like a relatively new concept in Canadian trademark law to talk about bad faith. I think you mentioned that it was in 2009 when that language was introduced into the statute. In franchise law, bad faith is an old idea in Canada anyways. And so the jurisprudence is quite mature about it here on the franchise side, where we now have a pretty good idea of what constitutes bad faith and what might not. And it'll be interesting to see how the trademark case law develops, because in this example, Mr. Mung was clearly a bad actor, and his conduct was easy to impugn, but sometimes there might be conduct that falls shy of that, where there might be legitimate competitive interests that a competing registrant might want to pursue that might not be bad faith. It'll be interesting to see where that goes.
Yeah, definitely. I think that's a good comment. The bad faith provisions were introduced in 2019 with the latest slate of amendments. And you know, it's true that it is new in the sense that it's expressly mentioned in the Trademarks Act, but the concept of bad faith has been relied upon in older cases under different provisions. But what's new is that it's now kind of right in your face that you can actually rely on bad faith. And for anyone who wants to successfully plead bad faith, I highly recommend a look at the Beijing Judian decision, because the court did a really good job. The judge there is another former IP lawyer. She did a very good job in reviewing all the different factors and coming up with considerations. So, you know, I think you're right, Edan, that legitimate and commercial interests would not constitute bad faith, definitely. And even just a knowledge of a competing mark is not sufficient, or knowledge that someone else might have rights is not sufficient. So a case that I successfully litigated in the federal court last year, we did manage to get the trademark registration struck, but the only ground that I did not win on was bad faith. So we were not able to show bad faith in that case.
Okay, well, it looks to me like we are out of time. I don't see any questions in the chat box, but of course, if anybody has any, our emails are on the screen. We encourage you to reach out to us. We'd be happy to talk about anything that we raised in today's presentation. And I think that's probably all we have, and we'll hand it over to Dan.
Brilliant. Thank you very much, Edan and Stephanie, for your insights and thoughts today. We really appreciate having you with us. We have a little bit of time. I do always like to ask at the end of this, Stephanie and Edan, I'm sure you have some thoughts, just what key takeaways you'd like our audience to leave today's session with. So if you could share those, that would be greatly appreciated.
Sure, I think I can sort of wrap up where I started with that quote from the Kentucky Fried Chicken decision, which is the most precious asset of a franchisor is its trademarks and its system. So, you know, the two things are so intrinsically linked. What we see from time to time in our practice is franchises that are really gung-ho to expand into Canada, and they're so focused on kind of the business aspects that they may not be paying as much attention to the trademark and whether or not the trademark is going to fly in Canada. So simply because you have trademark rights in another country, of course, does not mean that you're going to get those same rights here in Canada. So the trademark should really front end the franchise discussions, but very often, or I shouldn't say very often, but from time to time, it tends to be a secondary consideration rather than a primary consideration. So.
Brilliant, thank you, Stephanie. And Edan, if you have any thoughts or closing comments.
I just thought that it was a neat presentation that Stephanie put together, and I just wanted to thank you for that. It was a lot of food for thought for me as a litigator. And I hope it was of value to everybody here as well.
Brilliant, thank you, Edan. And yes, thank you very much to our audience for being with us today. If you do want a copy of the slides, please do reach out to Stephanie and Edan, who will be more than happy to provide those with you. We will also be sending an on-demand recording to you after the webinar has finished today. So thank you very much once again to our panel, to Stephanie and Edan for their insights today. Thank you very much for being with us. I wish you all a good day. Goodbye.
Thank you. Bye-bye.